Zha Hyoung RHEE, Director General for the International Legal Affairs of the Ministry of Foreign Affairs, will make welcoming remarks. So let us give him a big round of applause.
His Excellency Albert Hofmann, President of the International Tribunal for the Law of the Sea, Professor Zha Hyoung RHEE, President of the Korean Society of International Law, distinguished panelists, and dear colleagues from the diplomatic corps, participants from all over the world, it gives me great pleasure to welcome you all to the 7th International Conference on the Law of the Sea. The International Conference on the Law of the Sea has served as a venue for academics, practitioners, and judges to share their invaluable insights on ways to develop the law of the sea since 2016. And it is a great privilege for the Ministry of Foreign Affairs to be hosting the conference in cooperation with the International Tribunal for the Law of the Sea and the Korean Society of International Law once again. I'd like to thank President Hofmann and President RHEE for bringing renowned experts and authorities of the day together. I also welcome all the panelists, members of the diplomatic corps, and participants who have joined us today. As you must be well aware, the theme of this year's conference is Law of the Sea for the Next Generation, Effectiveness of UNCLOS Revisited. It is the second of the 3-year Law of the Sea for the Next Generation series, which is designed to help us map out the course of the Law of the Sea regime in this unprecedentedly challenging era. Peaceful usage of the seas and oceans are increasingly at stake in various parts of the world. Illegal, unreported, and unregulated fishing shows no sign of abating, although the fight against IUU fishing has been waged for decades. Other global emergencies in our oceans, such as the sea level rise and ocean acidification, have long veered off the desired path. There is little doubt that these types of challenges fall within the broadly defined purview of the UN Convention on the Law of the Sea, and the current state of the world compels us to ask whether the Convention has succeeded in addressing these issues properly. The ambition of the Convention is made clear in its preamble. It is to establish a unified legal order that can settle all issues relating to the seas and oceans. Indeed, the UNCLOS regime provides a comprehensive framework that governs ways in which states exercise jurisdiction over the seas. Yet, as Ambassador Arvid Pardo duly put some 30 years ago, its provisions are often vague, ambiguous, and even silent on a number of issues. More often than not, it is left to the Law of the Sea community to fill in the gaps whenever an issue arises. Therefore, the question we should ask at this moment is whether our efforts to build the jurisprudence have been in the right direction, and if not, how we could turn the helm in such a direction. This year marks the 40th anniversary of the adoption of the convention. And this year's conference is dedicated to reviewing the judicial decisions made under the UNCLOS regime. With more than 30 cases submitted under Part 15 of the convention thus far, international tribunals have not been hesitant to provide jurisprudence for contentious issues related to the convention. Their case law now serves as a major driver for the progressive development of this field of law, and also as a litmus test for finding out whether the law of the sea has effectively stood the test of time. The conference can be divided mainly into two parts. The first two sessions will be focused on whether UNCLOS has been effective enough to address the challenges and achieve its core objectives, which comprise promoting the feasible usage of the seas and oceans and establishing a stable legal order for the oceans through its zonal-based approach. In the remaining sessions, we'll be dealing with the institutional aspects of the convention, asking whether the dispute settlement mechanism of UNCLOS has been solid enough to uphold the regime and fulfill its aim. This year's conference also features a session titled Voices of the Next Generation, which embodies the essence of the law of the sea for the next generation series. This session will be an opportunity for early career academics to share their perspectives on what the law of the sea regime should address to ensure a healthy and resilient ocean for our future generations. Representing future leaders, the panelists of the session will voice their concerns and urge the community to take action on issues that they deem critical. Ladies and gentlemen, a little while ago, I came across Collins Dictionary's word of the year, perma-crisis, which means an extended period of instability and insecurity. This not only best depicts the image I have of the current status of our oceans, but also explains why the framework nature of the convention is more important than ever. In such time of enmity and collective unrest, it is the convention that provides basic norms that every member of the international community can rely on when dealing with ocean-related issues and seeking compromise. Reviewing the jurisprudence of Part 15 will help us determine whether and how much we have succeeded in coming up with amicable solutions based on the convention so far. There will surely be some takeaways, which I believe will light the way forward in navigating through these challenging times. It will also help us envisage and create a future we want for our oceans and the law of the sea, which we'll be discussing in the finale of the law of the sea for the next generation series next year. I wish you all the best. Thank you very much.
Thank you very much, Director General, for your warmest remarks. Thank you.